In this video, I'm going to be talking about purpose trusts, and this video very much leads on from the previous video where I talked about the beneficiary principle and whether or not each version of the beneficiary principle accurately reflects the state of our law. So if you haven't seen that video, make sure you check out that video first before continuing with this one. In this video, I'm going to be talking about purpose trusts, and this video very much leads on from the previous video where I talked about the beneficiary principle and whether or not each version of the beneficiary principle accurately reflects the state of our law. So if you haven't seen that video, make sure you check out that video first before continuing with this one. The descriptive accuracy of the wider beneficiary principle, which I talked about in that previous video, is called into question by the existence of legally valid purpose trusts. A purpose trust does not provide for the trust fund to be given to a person or persons as cash, but instead specifies that it is to be spent on delivering a particular purpose. So a purpose trust does not intend to give individual cash payments, but is to give the money to deliver a particular goal, aim, and purpose. And purpose trusts appear to lack a beneficiary on either definition of the term, and therefore appear to contradict both versions of the beneficiary principle, as I talked about in the last video. When a trust is aimed at the fulfillment of a particular purpose, there is no equitable owner of the trust property. In other words, there is no individual who can wind up the trust and take absolute ownership of the funds via Saunders and Vautier, and therefore there is also nobody with a proprietary interest of the property. So there's nobody to whom the trust will or will not be paid out, as the trust fund is instead to be applied in pursuing and fulfilling a particular set of purposes. So the existence of legally valid purpose trusts seems to contradict the beneficiary principle as an accurate description of our law. So the categories of valid purpose trusts. There are three categories or types of legally valid purpose trusts. We've got charitable trusts, miscellaneous non-charitable trusts, and Re Denley trusts. A purpose trust not falling within one of those above categories is legally void. Okay, so a purpose trust not falling within one of these categories will not be a valid trust. So if X transferred money to the trustee for the trustee to apply that money for a particular purpose, and X's intended purpose does not fall within one of those three categories, then X will have failed to create a valid trust. Now, in the case of Re Astor, money was settled to a trustee for various purposes, including maintaining cooperation between nations and preserving the independence and integrity of newspapers. The trust was held not to fall under any of these three categories, so the trust was therefore held void. In Re Shaw's Will Trust from 1957, Shaw left money on trust for the creation of a 40-letter alphabet. The purpose was held not to fall under any of these three categories, so the trust again was therefore void and the money reverted back on a resulting trust. Okay, so let's look at these three categories in turn. Firstly, a charitable trust. A charitable trust is one aimed at exclusively charitable purposes, and I have made a few videos on charitable trusts as well, so do check this out if you're interested. So, for example, the purpose of encouraging participation in volleyball or protecting an endangered animal. So they are purpose trusts by definition and are aimed at fulfilling certain purposes, rather than being trusts aimed at paying out money to certain individuals. So this is one category of purpose trust the law accepts as legally valid. A charitable purpose is a purpose which falls within the list in the Charities Act section 3 subsection 1 and is for the public benefit under section 2. So you need to look at sections 1 and sections 2 of the Charities Act 2011, and I have got videos on those if you want to learn about that in a bit more depth. Miscellaneous non-charitable purpose trust. So the law has accepted as valid some non-charitable purpose trusts, but the ambit of non-charitable purpose trusts that the law accepts is extremely limited. So the following types of purpose trusts are held legally valid. You can create a valid trust if it's aimed at one of these four purposes. So the trusts accepted as valid are limited to constructing and or maintaining graves and monuments, and you can see that from the case of Re Hooper from 1932. Privately saying masses from Bourne and Keane from 1919. So we know that a trust for publicly saying masses will be charitable, as that would advance religion and be for the public benefit, but a trust for privately saying masses cannot be charitable. We've also got maintaining particular animals from Reed Dean in 1889. So a trust for maintaining animals in general tends to be charitable, but a trust for maintaining particular animals is not charitable because of a lack of public benefit. Nevertheless, this type of trust can be legally valid as a non-charitable purpose trust. And then also promoting fox hunting from Reed Thompson in 1934. So this is presumably defunct now because most forms of fox hunting are now illegal. And there are some potential other cases too, for example, trust for the benefit of unincorporated associations. And finally, we've got the Re Denley purpose trust. So the final category of valid purpose trusts are what are known as Re Denley purpose trusts. Trusts aimed at purposes are valid when there are individuals directly and tangibly benefited by the purpose's performance. So the principle in Re Denley is that a trust aimed at a purpose will be legally valid provided there are individuals directly and tangibly benefited by the purpose's performance. In Re Denley, a trust for the purpose of providing a sports field to be used by the employees of a particular company was held legally valid. So the sports field delivered a direct and tangible benefit to individuals, i.e. the employees, so the trust was held to be valid. The court held that ordinarily a purpose trust wouldn't be valid unless it were charitable or fell under one of the miscellaneous categories in the previous slide. But you can create a valid purpose trust provided that there are individuals directly and tangibly benefiting from the trust's performance. So it was held in this case that a distinction must be drawn between purpose or object trusts, which are abstract or impersonal and which are therefore void, and a trust, though expressed as a purpose, is directly or indirectly for the benefit of an individual or individuals. Such a trust, Goff said in this case, is in general outside the mischief of principle that every trust must have a certain cesti que trust. Decisions consistent with Re Denley. The principle in Re Denley underlies a number of other decisions. So, for example, Re Abbott Fund Trust from 1900, Re Aberconway from 1953, and Barclays Bank and Quizclose from 1970. I cannot believe that the trust property was ever intended to become the absolute property of the ladies, so that they should be in a position to demand a transfer of it to themselves. Also that if they become bankrupt, the trustee in bankruptcy should be able to claim it. I think that the trustee or trustees were intended to have a wide discretion as to whether any, and if any, what decisions consistent with Re Denley. So the principle in Re Denley underlies a number of other decisions, for example, Re Abbott Fund Trust from 1900, Re Aberconway from 1953, and Barclays Bank and Quizclose from 1970. And we have this quote here from Re Abbott Fund Trust from 1900. And in this case, a trust fund was created to provide for two deaf and dumb elderly sisters who lacked the means to support themselves. The trust was not held valid for the sisters' absolute benefit, but rather as a trust for the purpose of providing for the sisters. That purpose trust was held valid because there were individuals, i.e. the sisters, as in Re Denley, who were directly and tangibly benefiting from the purpose's performance. So in Re Abbott, we see the court apply the same principle as was applied in Re Denley. Purpose trust and the beneficiary principle. So purpose trusts clearly lack a beneficiary in both the narrow and wide sense of the word, but this does not dissuade those who consider the beneficiary principle as an accurate description of our law. Because purpose trusts are aimed at the fulfillment of a particular purpose. They clearly lack an individual who owns property in equity or has a proprietary interest in the trust property. In other words, purpose trusts clearly lack a beneficiary in both those wide and narrow formulations of the beneficiary principle. So the validity of purpose trusts seems to undermine the beneficiary principle as an accurate description of our law. So how can the beneficiary principle be accurate when trust law holds as valid various categories of purpose trusts who simply lack a beneficiary? Nevertheless, a number of academics continue to assert the beneficiary principle. So, a number of academics claim that at least the wide version of the beneficiary principle, in other words, that you need someone with a proprietary interest in the trust property for validity, is in fact an accurate description of our law. For example, Virgo. So, these advocates of the beneficiary principle have an explanation for the three categories of purpose trust that seem to imperil or threaten the beneficiary principle. Advocates of the beneficiary principle regard charitable trusts as exceptional, miscellaneous, non-charitable purpose trusts as anomalous, and Re Denley as wrongly decided. So, academics have provided these explanations for all the derogations from the beneficiary principle. In other words, they're saying that the beneficiary principle basically holds true except for X, Y, and Z. In other words, the three purposes provided. So it is clearly possible then to uphold the beneficiary principle, at least the wider version of it, as an accurate description of our law by explaining away the three categories of purpose trusts as exceptional, anomalous, or simply bad law. However, although this is possible, it may not be particularly sensible. It may be that these categories of valid purpose trusts are just too substantial or significant to make support for the beneficiary principle as a description of our law as either tenable or credible. So it may not be particularly sensible to keep invoking or asserting the beneficiary principle in light of these exceptions to it. And in particular, I think the beneficiary principle must yield, it must surrender as a description of our law if there is some other principle which better captures the state of trust law. It is all well and good saying that the principle is the beneficiary principle, subject to exceptions, but if we can find a better principle that better captures the state of trust law, then surely that would be a better principle to invoke. So, in the next video then, I'm going to turn to a principle that can legitimately claim to provide a better description of trust law than can the beneficiary principle, and that is the enforceability principle. So make sure you check out that video when it comes out next week. Anyway, if you have any questions at all about this video, then make sure you leave a comment or question below. If you enjoyed the video, then make sure you give it a thumbs up and subscribe to my channel. Thank you very much for watching.